of pay. For part-time employees, it's whatever their regularly scheduled hours would be for a 2-week period. Now, there are all kinds of nuances in each of these details that really what we'll be able to do is issue spot for you. But the intent here is pretty much every single employee is to be covered, okay? Full-time, part-time. And there are 6 reasons that someone could receive pay under this Paid Sick Leave Act. And the reason, an important thing to note, is the reason someone would get paid sick time is because the employee is unable to work or the employee is unable to telework due to one of these 6 reasons I'm about to talk about. So let me say right off the bat that one of the things that the regs, which, when did they come out? Yesterday, Laura?
It might have been like midnight the day before that, but yeah, they've been out for fewer than 36 hours.
So the Department of Labor has come out with what they're calling, temporary regulations that right now do extend for the length of the act, so through December 31st, 2020. And they've said the employee needs to be unable to work or telework for one of these 6 reasons. Either they're subject to a federal, state, or local quarantine or isolation order related to COVID-19. Many of us are under those, although many of us are able to telework. And so those of us who are able to telework, even though we are under a quarantine or isolation order, I should call it, a stay-at-home order, we would not be eligible for this paid leave because we can telework.
Now, Susan, let me just jump in here. I am making distinctions between quarantine, isolation order, et cetera. I think they're using those different terms intentionally. I do think that the stay-at-home work order would give someone leave if they're not able to telework under this, unless they fall into one of the many, many exemptions from the order. So if you fall into one of the exemptions from the order, for example, my childcare clients, even though you can't really telework and watch a classroom of 2-year-olds, I mean, you could, it would be kind of funny actually, but not particularly safe. So don't do that. So even though you can't telework, because they're an exempt industry, they would not fall under this category because they are not subject to this stay-at-home order. Now, if there's a specific county order, like say a county health department directs that for 72 hours, if someone has one symptom of COVID, then you must shut down, then you are subject to the to this first exemption, if that makes sense.
Yeah, so that's exactly right. So the point of this is, it turns out that implementation of this is going to be very technical. And it is important to understand sort of this broad perspective we're going to give you. But for any of you who are going to be advising clients, you are going to need to have digested all 125 pages of the regulations. And that's what they are right now that have come out. If any of you want to email us later, we'll give you the link to them because they're not yet published in the CFR. Okay, so someone gets paid sick leave for 6 reasons. We've talked about one of them. They can't telework because they're subject to a local quarantine or isolation order. Number 2, they've been advised by a healthcare provider to self-quarantine. Now, the regs have expanded this and told us that what this means is if a healthcare provider comes along and says, in my medical opinion, I believe that this particular employee is particularly susceptible to COVID-19. And for those reasons, I'm ordering him or her to self-quarantine. That counts. We thought it might be narrower than that, but it can be that broad. So it's, very possible. And in fact, one of my clients has already received one of those notices from a healthcare provider for a woman who is pregnant and received this notice from her healthcare provider, even though there's no imminent threat of COVID-19.
Now, originally, we said that this quarantine had to be because someone was exposing symptoms and they were a danger to other people. But Susan's right with this, 36 hours ago, this new clarification, we think it covers those categories. Where you can expect that is going to be folks who are pregnant, with diabetes, with asthma, yeah, things like that. Folks who've recently undergone cancer treatments and their immune systems are a bit weaker. Now, remember, they may be directed to stay home for the foreseeable future, but they only get this leave for 2 weeks. So
right.
What I think we're going to see are folks who are excited about this 2 weeks at home. And this is me being jaded and employer slanted, so I apologize for that if it's offensive. But we're going to see employees who are excited about getting this 2 weeks of leave. And then they're like, all right, now I'm ready to come back. Well, you're still pregnant. So now are you going to get a doctor that says it's fine for you to be there? So before someone comes back to work after this leave, a return to work note from their doctor is totally appropriate thing to ask for, whether it's because they had symptoms or because their doctor thought they were particularly susceptible.
Yep. Okay, number 3, the third reason they get paid sick leave is because they're actually experiencing COVID-19 symptoms and seeking a medical diagnosis. The regs say that right now we're defining COVID-19 symptoms as fever, dry cough, can't remember the third one, or any other symptom.
Difficulty breathing.
Thank you. Difficulty breathing, or any other symptom that the CDC comes out with. So that refers us to the CDC. And they have to be actively seeking a medical diagnosis, however. They can't just decide that they have a cough to stay home. Reason number 4, they're caring for someone who is subject to a quarantine or isolation order related to COVID-19. Or they're caring for someone who has been advised to self-quarantine by a healthcare provider, as we just discussed. There are some parameters in the regs that let us know that caring for really is meant to only be someone in the home that you actually legitimately need to be caring for. And the regs did include roommate as someone that could fall into this category. Some folks have posed questions to us. Well, what if a member of the household has been hospitalized? Well, right now, we don't think that's actually covered because the hospital is caring for the person. And at least right now, for COVID-19 reasons, there are no visitation abilities. So that's really for caring for someone in the home. Reason number 5 that you get paid sick leave is if your employee is caring for a child whose school or place of care is closed, or, for example, if the child care provider is unavailable for reasons related to COVID-19. Maybe their daycare shut, maybe you have a nanny, but that nanny herself has been experiencing COVID-19 symptoms, or has a healthcare provider opinion that she needs to self-quarantine, and so there's no child care. This is going to be a big one for a huge number of people in our state and in many other places because of all the schools that are shut down. So this is one that we really need to drill into more in any particular situation. to really understand what both employee and employer obligations are. As an initial note, one of the things that the DOL said in the regs was, hey, I know that the Act itself said this could only be for a child who was under 18, whose school is closed. But part of our job as the Department of Labor is to interpret these two acts to be consistent with one another and consistent with the Family Medical Leave Act, which has been in place for years. And so the DOL came out and said, we think what really should apply here is if you have a child who's over 18, but who has a disability or other condition that requires your direct care, and that older child's normal care is also interrupted for these reasons. So that's a big thing that's changed. Before, we were telling clients go on the face of what the statute said, could only be for a child who was under 18. The DOL has changed that and said, if you have a child over 18, that's already covered under the provisions of the regular FMLA. We think that person should be included for the purposes of paid sick leave. Okay, number 6 is a catch-all. If your employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in connection with the other agencies. The regs will talk more about what those might be. So again,
So
go to the
I think so far, feedback. It's weird. I think so far what would fall into that category would be like H1N1 or MRSA, something like that. People, they're doing some testing, I understand, for H1N1 for other different kinds of flu. And because H1N1 has already been identified as a pandemic, it would probably fall into that category. But otherwise, I think that's sort of a wait and see catch-all so that they can be really kind of nimble if the CDC identifies another version of this virus or something similar.
So just a quick note on, we're telling you that this is paid sick leave. You've got a max of 80 hours for full-time folks who are 40 hours or more. Part-time is anything under 40 hours. But there are different rates of pay that you need to pay attention to for your clients. Basically, if you're taking paid sick leave for any reason that really is related to you, you're the one under the isolation order. You're the one trying to seek a medical diagnosis. You're the one subject to the quarantine order. Then you get your pay, your full pay, whatever your regular rate is. The higher of whatever your regular rate of pay is, or the applicable minimum wage, up to a cap. And the cap is $511 per day. And if you take that number and spread it out over a 2-week period, there is an aggregate cap for each employee, which is $5,110. If your employees are taking leave for the other reasons, their pay is 2/3, the higher of 2/3 of their regular rate of pay, or 2/3 of the applicable minimum wage. Again, there's a cap. Employees need not be paid more than $200 per day, or $2,000 in the aggregate per employee over that 2-week period. There is the intent of this act. Well, actually, there are tax credits, and we'll talk briefly about that at the end once we've gone over how both of the acts work. So that's the paid sick leave in a quick nutshell. All kinds of nuances will be spelled out in the regulations. For example, one of the key things that the regulations say is if the employer has had to close down because of, even though it's because of some, let's say the governor's order, and the place of business isn't working and has no work, employees are not entitled to this paid sick leave, even if they have COVID-19, or even if they're trying to get a diagnosis. And that is because there is no work, there's no telework, and the employer is not required to then pay for this paid sick leave. And the regs say, go ahead.
So I was just gonna say, I see a difference here between folks where the employer has shut down and where they've put employees on unpaid leave. So if they continue to be an employee and they're receiving health benefits, I read them as needing to provide leave in those circumstances, or if they've really just reduced everybody to a couple of hours. I think that's different from if they're closed down. Do you still agree?
Yeah, I think that is different. And right now, what the regs just addressed is if the business closed down and they don't have the work, then, and the regs said, you know, then the employee should go file for unemployment insurance, even if it's just for a 2-week period of a shutdown, or even if it's just a 4-week shutdown. Okay, we're going to move to the next portion that's important for this Families First Coronavirus Response Act, and that is an amendment to the Family Medical Leave Act. This Family Medical Leave Act expansion, again, applies to these employers who have less than 500 employees. That's a huge difference. In the past, or not in the past, but as it stands, the regular Family Medical Leave Act only applies to employers who have 50 or more employees who work within 75 miles of each other. Now we have a Family Medical Leave Act that is an emergency act, and the provisions of the emergency FMLA, not the whole FMLA, but the emergency FMLA, applies to these employers with less than 500 employees. And so there is really many provisions of the regular FMLA apply. And so, for example, this leave is a 12-week leave, just like regular FMLA. However, a huge difference is that the first 2 weeks are unpaid and the remaining 10 weeks are paid by the employer. Now, there is only one reason that someone gets EFMLA, as we're calling it. And that's really this number 5 that we were discussing under the Paid Sick Leave Act. If someone cannot work or telework because they're caring for a child whose school or place of care is closed, or their child care provider or the nanny is unavailable for reasons related to COVID-19. No other reason is the EFMLA invoked. However, you know, while I've said that the first 2 weeks of EFMLA are unpaid, an employee can choose to substitute the first 2 weeks of that as paid under what we just discussed as the Employee Paid Sick Leave Act, because those 2 reasons are the same under both acts, and the regs say we will interpret them the same. If you qualify for emergency paid sick leave under this provision, you will qualify for EFMLA. And so employers potentially could be paying up to 12 weeks of paid time for employees who cannot work or telework for these reasons. And again, this wouldn't apply though if the business itself has had to close and the business has no work. This is only if the employee himself or herself cannot do the work that the employer would otherwise have. Again, the pay under the EFMLA is not full pay. It's paid at 2/3 the employee's regular rate, or 2/3 the minimum wage, whichever is higher. And then the aggregate pay, of course, is increased to the most you would have to pay over that 12-week period, if they used all 12 weeks as paid, would be the $200 per day and the $12,000 in aggregate. Both of these laws do provide for an exemption possibility for employers who have less than 50 employees, that Laura will talk to us about.
So the exemption was, we didn't know anything about it at all until these regs came out. And I have prepared a version of the regs with all the exemptions highlighted. If anyone wants me to email them to them, just let me know. But basically what it's saying is that you have to prove that that you are in trouble and your business may have to shut down, basically, if you have to comply with this. So they're focusing on whether this will cause an ongoing concern for you related to your business productivity. Now, you don't need, we have a 30-day from the first safe harbor in enforcing this. You don't need to mail anything in to get an exemption. Under the regs, they estimate that maybe 10% of businesses will be exempt, but they don't really know. I would anticipate they will read that fairly narrowly. So, for example, if you're in an industry where all of your folks are going to end up taking this family leave, say you're in just an organization where a lot of your folks are parents, then that could be a concern. So I'm just trying to see if there's anything. The business is considered to remain viable for the foreseeable future unless you can demonstrate that otherwise. So the criteria is fairly vague still. Such leave would cause the small employer's expenses and financial to exceed available business revenue and would cause the small employer to cease operating. The absence of the employer or the employees requesting such leave would pose a substantial risk to the financial help. So if you're a service organization and by allowing these folks to stay home, you can't operate, then they'll consider that. And then also that if you can't find enough workers somewhere else to do your job, those are factors they'll consider. And that's about all we know so far.
We kind of expect that there may be a lot of smaller businesses with less than 50 who may apply, but probably not a great deal of them will be granted that exemption. Yeah. And so at least the EFMLA has tried to provide another helpful point for smaller employers who are not able to get this exemption. And that comes on the back end of this leave. What happens when somebody has used up their 12 weeks of leave? Well, like under the FMLA, they would need to return to work, and under the regular provisions of the FMLA, the employer has to bring them back, has a reinstatement obligation to bring them back in the same or substantially similar position. Well, the same exists. The same reinstatement provision exists for EFMLA. in theory, of course, assuming the employee can come back. Well, the Act does say if you're really small and you have less than 25 employees, you have a different reinstatement obligation. First, you do need to try to bring them back under the typical reinstatement obligation. You need to make good faith efforts to do that. And if you can't do that, then you should try to hire them back still in a similar position within 1 year from the time that they have either taken leave or first asked for leave. And if you can't do that either, you need to stay in touch with them about your open positions. So there's still plenty of potential obligation on the backside of this leave for all size employers. The intent of this act was to really make this leave not be a hit, shall I say, to employers' payroll, to employers' costs, because the act is to give tax credits on a dollar for dollar basis, on a dollar for dollar reimbursement basis for the employer for as long as the employer adheres to the caps, pays the cap or less. And early on, I guess the DOL came out with some guidance about that, and then the IRS got upset, as I understand it, and said, no, we're the ones who are qualified to talk about the tax credits. So I just say that in case you may have received, if you got earlier guidance or even law firm announcements that talked about what the DOL said about the tax credits, you now need to make sure that you are going to the Department of Treasury website to see exactly how those tax credits work. The intent of them is that the employer should be able to deduct whatever they paid out in these paid leaves from their payroll taxes as the IRS specifies in their next payroll cycle. And so, of course, the hope is that this will not be immensely painful for an employer. Of course, you still need to have the cash flow to be able to make these payments to folks who are out, as well as any employees that you still have working. I want to just talk briefly about the notice requirement under these two laws. So the DOL says that both of these laws became operational April 1st, effective April 2nd, and expire December 31st, 2020. We're telling everyone, and I think everyone's going by you need to be up and running with this as of a couple days ago, April 1st. So there's a poster that the Department of Labor has come out with that's both in English and in Spanish, or one's in English and one's in Spanish, and they may be trying to create other versions in other languages. But you have to post that in a conspicuous place at the workplace, just like, they're the typical posting requirements. Well, the DOL has gotten very granular about what exactly that means. And so if all of your people are teleworking, you need to email a copy to every one of them. If you've got a workplace where, people aren't really congregating in the lunchroom anymore because of isolation, trying to stay within the social distancing parameters, you're going to need to place that poster in lots of different places across your workplace so that you can make sure everybody really has seen it. Laura mentioned that there's going to be there'll be a 30-day period where the DOL isn't going to enforce penalties or, in fact, violations as long as the employers are acting in good faith in an attempt to comply with this. And I would just think that sending out these notices properly would be one way that you could prove you were intending and trying in good faith to comply. So that's what I wanted to say about those acts. And Laura has great dovetail information about how the ADA overlaps.
Yeah. All right. So one of the things, well, let me say one thing about the state act. So the state leave act, it's only right now, it's only for another I don't know what, 6-7 days. It was enacted on the 10th or the 11th, Susan, do you remember, of March?
March 11th, I believe.
March 11th, and it's for 30 days. So it's about to expire. So unless they extend it, it'll go away. What it does is it provides employees with 4 calendar days to obtain a test. That was issued in response to the delay in everyone's experience with testing. Now the federal act will take care of that. So I don't know that it'll happen. It's 4 calendar days, which means that if I am advised on a Thursday to go obtain a test, and so I stay home on Friday, I get the test on Saturday, I find out on Sunday that I'm negative, then I just get that Friday off. It's calendar days, not work days, assuming I work a traditional 5-day week. Also, you only get that leave until either you have a negative test or the 4 days expires. So originally this was really an issue because it was taking folks a week to do that, and now it's not. So we'll talk a little about the ADA, and then the last thing, if we have any time, we can at least give people the 2 cents that we know about unemployment, because that's been a lot of our questions in the last couple of days. So one of the things that I think we're trying to remind people is, even though we have these new laws to comply with, we need to not forget about the old ones. For example, under the Fair Labor Standards Act, if you have someone who is a salaried exempt employee, meaning they satisfy an exemption under the Fair Labor Standards Act, and you're not obligated to pay them minimum wage and overtime and track hours in that way, if you reduce their pay below $684 a week, which is the salary minimum, and their exemption was based upon a salary minimum, then they're no longer exempt and they need to be paid hourly, and they need to receive overtime. Similarly, if their duties have changed, if historically this person was exempt because they were managing more than 2 people and making decisions of significant importance to the business, and that's no longer happening because now they're a direct service provider, then they also may lose their exemption. So you want to make sure that as your employees' situations change, we don't forget about the laws that we were in compliance with a couple months ago, but now because things have changed, we are not. So what that means is if you do have to change your employees, what we're kind of thinking makes the most sense is to create kind of a new temporary position and say, you're COVID administrator or something, as opposed to just go flip-flopping the way you compensate employees, going between hourly and salaried, because you may want to return them to the salary if they, again, fall under the exemption. The Department of Labor doesn't like to see us flip-flop back and forth between hourly and salary. Does that make sense, Susan, to you?
Yeah, absolutely.
So then the other thing is that we're seeing a lot is if you traditionally do have to comply with the Family and Medical Leave Act, the regular one, not the emergency one, when someone comes to you with a leave, you want to say, okay, let's just back up. Who is this person? What leaves are they entitled to? Are they entitled to use PTO under our policy? Do they have to? Can we force them to? Are they allowed to keep it for a while? And then, are they entitled to any sort of medical leave under our policies? Are they entitled to FMLA leave, which would give them that 12 weeks of unpaid leave, and then some rights to come back and get their job? And are they entitled to disability leave? So if someone has a disability and somehow this is triggering it, so let's use the example of the pregnant employee. Pregnant employees are treated as kind of a hybrid between being pregnant and sort of a gender claim, which and then so it's a combination between gender and disability. Sorry. And as someone who's been pregnant twice and had 2 children, I find that to be both accurate and offensive in equal measures. Like, I wasn't disabled, I was fine. Oh, yes, I kind of was. So, not that being disabled is a bad thing, it just feels sort of weird. It's sort of a made up kind of category. So folks in that category are entitled to protection under the Americans with Disabilities Act, separate and apart from any benefits they might be entitled to under these new emergency acts. So if I'm going out on maternity leave and I'm going to go early because of COVID, I might be entitled to the 2 weeks of paid sick time. And then I might be entitled to some sort of maternity leave. And then I might be entitled to additional unpaid leave, so that I can continue to recuperate from birth or until I have the baby. So one of the concerns is that under the Americans with Disabilities Act, we can't ask a ton of questions about our employees' health. Typically, you don't want to do that. Here, because information about their health is going to trigger whether they're entitled to this leave, we are allowed to ask some additional questions. So we're not allowed, for example, to ask general disability related questions. For example, asking an employee if their immune system is compromised, that's a disability related question. So you can't ask that question. The kinds of questions you can ask are, you could do, for example, a survey of your employees and ask them general questions like, hey, here are 4 things. If schools or daycares are closed, would you need to care for a child? If services were unavailable, would you need to care for other dependents? If public transport were unavailable, would you be able to work? If you or a member of your household falls into the categories identified as someone being at high risk, would you need leave to take care of them? And then they say yes or no to all of those questions, as opposed to identifying which of those categories they fall into. When it comes to particular symptoms, because this is considered a pandemic, which is a global epidemic, you're allowed to ask questions like, do you have a cough? Do you have a fever? Do you have other symptoms identified as indicating that you may have COVID? You're allowed to ask those questions. Again, typically we're not allowed to ask those questions. You are allowed to take employees' temperatures, which is something that normally would be considered a medical exam that you can't do. So on one hand, you're allowed to ask more medical questions than you typically are. On the other hand, they're also encouraging us to accept more informal documentation than we might ordinarily request. So for example, if someone's going out on family and medical leave, you may typically require them to, fill out the FMLA leave form. And I'm talking about the traditional, not the emergency. Here, you may be required to accept kind of an email that goes over those questions and not the actual form. You can get the form later. Or instead of getting an official doctor's note, you may have a doctor's text or a doctor's email, because we don't have that in-person interaction. So what I would say is, if any of your clients do have folks who are disabled and are going to need some sort of leave particularly related to their disability, if you think the ADA might come into play, then advise them to seek counsel. This is not a time to sort of play fast and loose with the requirements of that statute. All right, maybe we can talk about some of the questions we're getting from some of our folks. And Susan, jump in. I can think of 2 that I've gotten many times. One, what if you have employees who want to stay home because they're freaked out and they just feel like it's safer? I think it's appropriate to look at your policies, see if they're entitled to any sort of unpaid leave, see if they have any PTO coming. If they aren't entitled to leave under any of the federal statutes that we've just discussed that are new, or any of the sort of traditional statutes, then effectively I would just confirm with them, so your last day is blank. We don't have to be mean and say you're terminated or you quit if those words are, sort of triggering. But we can. The point is, you need to make clear to those people whether they are employees on unpaid leave or whether they have separated employment. You can always tell them, like, please let us know if your condition resolves, or if you decide that you want to come back, or if you're interested in part-time work. maybe you come back and they don't have to do an interview, but you need to make it clear to them whether they're employees or not. What if you have to reduce hours? So you're trying to keep as many people on as you can, but you need to reduce hours. So everyone is, 4 hours a day instead of a typical 8-hour day. Those folks are entitled to apply for unemployment for reduced hours if they fall below 32 hours a week. When you receive their application, you have the opportunity to say, this person is job attached. You'll be asked if they're seasonal or job attached. What job attached means is it means that you are making a representation as an employer that you're going to rehire this person within about 16 weeks. And what that does is it limits the amount of work it should, and that the Department of Labor has the discretion to, and they typically do. It limits the amount of that person's going to have to do to demonstrate that they're cooperating with the job search requirements that the Department of Labor unemployment folks typically have. So typically when you're on unemployment, you have to document all your job search efforts. If you're job attached, your person may not have to do that. The benefit there is it's a pain and kind of pointless right now. And also number two, it encourages them to come back to you. They feel attached to you to the extent you want to preserve that workforce.
One of the questions I've been getting is from some folks who are sort of in the healthcare industry. My gosh, does this apply to everyone? And while this has not been particularly a popular provision of these acts, they do say that employees who are healthcare providers or emergency responders can be exempted from the leave requirements under these acts. In other words, the employer need not give it to folks who are defined as healthcare providers or emergency responders. And it does caution employers to try to be judicious when deciding whether or not to invoke this. But it does have that out if, people are first responders and you need them to be first responders. You can't prevent them from taking leave if they already have, leave under other PTO or other policies. But you can find a way to exempt them under these federal acts. So that one is really quite a conundrum for employers.
That's a good point. Another couple points, some of the local associations, like the American Dental Association, if you go to those pages, if you work for a particular industry, they have useful checklists and things like that for folks during COVID. Also, if in doubt, go to the CDC. I mean, if you're relying on information from the CDC or your local health department, I think that drastically reduces any chance that you'd be later sued for some sort of discrimination, because you're relying on not your own internal biases or thoughts on whether folks who are over 65, for example, should be in the workplace because it's dangerous, but you're relying on information from a government agency. So to the extent you can look to a neutral third party for that kind of business decision support, I think that's useful. Also, 2 points with respect to unemployment. I do not yet know whether or not they're going to grant unemployment for people who decide to stay home because they're freaked out about COVID. Now, does that mean typically if your environment is dangerous, then you can stay home? But if you're open and you want someone to work, but they voluntarily separate, I don't know if they'll be able to get unemployment or not. My instinct is that they're going to hand it out like candy, but I'm just not sure. The concern that some of my people have about that is because the Federal Unemployment Act is allowing this new $1 trillion stimulus bill is going to give folks $600 a week on top of whatever they'd be entitled to, which for some people is more money than they're making at work. So if I am entitled to, the 65% of my income, and then I get another $600 on top of that, that's currently going until July 31st. I don't know how you're going to get your employees to come back before July 31st. Traditionally, if you have someone who's job attached and you offer them a job, then, and they say no, then their unemployment is cut off. But I don't know if that's going to be the case right now because of the COVID situation. So one of in the service industry in particular, a lot of my clients are kind of freaked out, restaurants, bartenders, things like that, because that $600 they're afraid will just make everyone want to stay home.
There'll be questions that come up about whether under this EFMLA anyway, can leave be taken intermittently?
Oh yeah.
You know, in other words, do these employees have to take their full 12 weeks consecutively, all 12 weeks, or can they take it in smaller chunks? So the regs do address this, and so this is something that if this is coming up for you, either as an employer or an employer, you should look at the provisions of the regs. But basically, there needs to be a mutual understanding, whether it's written or not, that the employee can take intermittent paid sick leave or intermittent EFMLA. And they need to agree about what those increments of time are. So far, the way I interpret the regs, they're saying it needs to be an agreement on both sides. So, you know, again, one of the questions that comes up is, well, there are periods of time where somebody can telework, and hence they're not eligible to receive any of this if they can telework. Remember that? But there may be times during the week where they can't telework. I've seen this come up a lot with divorced families where one working parent has care of the child for half of the work week. And in that half, they literally can't telework because their child is of such an age that they really need to do on-care work. Well, can they take intermittent leave for that period of time? And right now, although I haven't done a deep dive, it looks like that needs to be agreed upon between employer and employee. I can tell you, I'm sure the intent is for the employer to agree. Because there are certainly, as an aside, these laws contain all the same provisions that most federal laws do, which say, you know, you can't try and interfere with someone's ability to take this leave. You can't discriminate who gets to take this leave and who doesn't. You can't retaliate and terminate somebody because they've asked for this leave or they've raised a question about this leave, you know, and you don't want to deal with it, so you'd rather just terminate them. All of those same adverse actions are prohibited.
So one other point that I don't think we talked about when calculating the how much to pay folks under these leaves, if they're part-time, if you had someone, say you have someone who was reduced to 4 hours and historically they worked 8 hours a day, if you're trying to figure out what rate to pay them, you have to have a conversation. Susan's comment about agreeing with the employee is what I was thinking of. You have to at least talk about it and figure out what it is. If you can't agree to it, then you do an average of the last 6 months is what the regs are saying. So look at the regs before you start calculating that. But at least initial guidance said we could agree, but if you can't, there are mechanisms for sort of how you can come up with that dollar amount.
That's what we wanted to present. I don't know, Miranda, if this platform allows questions, or if you would like to wrap us up, or what?
So it does allow questions too. If you look right underneath the bell icon on the left-hand side of your screen, it says chat. And that's one way to ask Laura and Susan questions. The other way is just to unmute your microphone. I think Anybody have any questions?
I don't see any in the chat.
Yeah, I don't either, but I just wanted to circle back and say thank you to both of you. You are two of the leading voices when it comes to interpreting kind of the real-time changes in employment law in Colorado. And we recorded this session, and so it will be available for people that could not attend live and might need to revisit some of the more complicated aspects of what you discussed. So we'll be able to put that on the LawBank website. But if anybody has any questions, feel free to reach out to Laura and Susan directly, also to me or to Kimberly, and we can redirect to them. But otherwise, thank you so much to you both.
Thanks to everybody. Wash your hands and stay safe.
Wash your hands.
Have a nice weekend.
Bye.
Thanks. You guys too.
Bye.
Bye-bye.